All right, hold on, let me just... I want to talk to you today about the hidden dangers of jointly owned property. And I want to talk to you about this because jointly owned property is really popular. Almost every client that walks in our door has some property that's owned jointly with other persons, either a spouse or children. And sometimes we have clients that come in and practically everything they own is titled jointly with somebody else. Now, there's a lot of appeal to jointly owned property. Joint ownership feels good. It communicates the idea that that we're partners in this, and that we're all in this together. It's all for one and one for all. And it also has the benefit, or at least people think it has the benefit, of avoiding probate, and sometimes it actually does, depending on who dies in what order. But I want to talk to you about jointly owned property today because there are some hidden dangers in jointly owned property that people don't think about and are never discovered by them, but are dangers that are exposed after a person becomes incapacitated or dies. And I just want to say that jointly owned property doesn't really avoid probate, although a lot of people believe it does. It does not avoid probate. What it does do is it postpones probate until the last joint owner dies. It is true that if 5 people are joint owners with right of survivorship of property and one dies, then the ownership of that property just passed to the other 4, and there was no probate required. Nobody had to even go hire a lawyer. So there's a lot of appeal to joint property because it does seem on the surface really simple. And it actually works that way. Oftentimes if everybody dies in the order they're supposed to. But we're old enough now and we've had enough experience at this that we know that people don't always die in the order they're supposed to. But a problem with jointly owned property is that it exposes the entire asset to the creditor claims of all the joint tenants. That means that if mom retitles all of her property so that she and her 3 children own the property jointly, that would be 4 people. Mom and the 3 children are all joint owners. What that means is that if you have one son who doesn't pay his child support and his wife gets a judgment against him for it, that wife can come down to the bank and levy on that joint CD and take all of that money out of the account to satisfy that judgment. And that's a problem with joint tenancy that a lot of people didn't know about. Another risk is the risk of accidentally disinheriting people that you would not want to disinherit. And I want to spend a minute talking about that, how that works. I've seen this happen so many times. It's really heartbreaking to see outcomes that I know in my heart of hearts are not the outcomes that the client would want. And in order to illustrate how this works, I've done a little animation here in my slideshow to help make the concept. And so here I want you to imagine an example where the mother has put the title to a bank account or real estate into the name of herself and her 2 sons and daughters, so that all 4 of them own the property jointly. We see this happens often, and it typically happens after one member of the couple loses a spouse. So if a husband and wife have everything that's owned jointly and the husband dies, then the wife realizes that everything is now hers, and all of that happened very conveniently. It happened automatically at her husband's death, and she didn't have to go through any probate proceeding. She didn't have to hire lawyers to do this. It all happened really instantly and automatically when the husband died. And so her reaction to that is, gosh, that was really easy, that was really convenient. And so what I think I'm going to do is do that over again, that same arrangement. I'm going to go put all my children's names on everything so that when I die, we will avoid the probate process. And there are a number of problems with that. And one of the problems that we have here is if mom becomes incapacitated and the children sit down and agree that this property needs to be sold, maybe it's because this is how we've got to pay for mom's nursing home care. The problem is that when we go to sell the property, the children discover they actually can't sell the property because mom's incapacitated and she does not have the legal power to sign a deed or to deal with the property in her own behalf because she lacks the legal capacity to do that. And what that means then is that the children have to go to probate court and have a guardian created, have mother declared incompetent, and have a guardian appointed for her so that that guardian can go to the closing and sign the closing papers to sell that property on her behalf. What that also means is that in order to sell that property, we actually have to have not just the mother or her guardian sign off on that, we also have to have all three of the children sign off on it. But more significantly than that, we also have to have the children's spouses sign off on it, because the title company, if it's real estate, the title company is not going to give clear title to this property unless the spouses of son 1 and son 2 and the daughter also sign off on the property. And so I quite often say to clients, if you put other people's names on joint property, you just gave up control of your property. Now, I've asked clients many times, are you willing to give up control of your property? And clients will say, oh no, of course not. I would never want to give up control of my property. But when you put your property in joint names with others, that's exactly what you did, because to sell that property or to give it away, you have to get the consent of these other people, including the spouses of these adult children. So that was one problem. But in this illustration, I'm focusing on the example of a certificate of deposit that's put in joint names with these children. And what happened here is that, and we see this happens. I mean, it doesn't happen every day, but it happens among our clients. It happens, you know, enough that we notice it. A child will die before the parent does. And so in my example here, son number 2 died before his mother, and then his mother passed away later. And so the question is, at that point, who gets the CD? Who owns this CD? I've presented this example in dozens of live presentations where I would have a group of people and I'll ask the question and I'll give people in the audience a few minutes to think about it and to tell me what their answer is. And it's really interesting to see the different responses that I get. The answer that I get most frequently, however, is that the property passes to son number 1 and to the daughter and to the grandson and the granddaughter. And I think the reason I get that response is because most of us intuitively know that that's really what the grandmother would have wanted. It was not her intention to disinherit the grandchildren, but that is exactly what she did by creating this kind of joint tenancy arrangement with her children, because the way joint tenancy works, whether it's a CD or whether it's real property, is that when somebody dies who's a joint owner, what that means then is that the other people who are still living become the sole owners. And because the grandson and the granddaughter didn't have their name on this CD, they didn't receive any of it. Now, I've had clients who've said to me, well, you know, if that happened, if I did this, if I set up this kind of arrangement and that happened to my family, I'm just quite confident that my children would do the right thing and make it right with the grandson and the granddaughter. And I have seen examples where it did work out that way. But I will tell you that I've also seen many examples where the children said, you know, my mother's a smart lady, and she knew exactly what she was doing, and she knew how this worked, and the way she set it up and the way it's working out is exactly how she would have wanted it. And so we have no obligation to share anything with our deceased brother's 2 children. Even if they do the right thing and make the decision to transfer property to the grandson and the granddaughter, we have to think about the gift tax consequences of that, because we know that when son one and the daughter make a transfer to other people to whom they have no obligation, no legal duty to make that transfer, then that's what we call a gift. And that means we have to think about the gift tax implications of that. And if it's a small, if this is a small amount of money or property, it's not that big a deal. But if this were a significant piece of property, that is a factor that really does have to be taken into account. So even if our children are really prepared to do the right thing, there are potentially adverse consequences to them from a tax perspective for doing that. So let me just sum up and make the point that the joint ownership of property does not avoid probate. It only postpones the probate until the last joint owner dies. It exposes the entire assets to the creditor claims of all the joint tenants, and it risks disinheriting people that you would not want to disinherit.